Welcome to the Colorado Trial Lawyer Connection, where Colorado trial lawyers share insights from their latest cases. The pursuit of justice starts now. Welcome back, everyone. Keith Fuicelli here for another edition of the Colorado Trial Lawyer Connection podcast. Super excited this episode to talk about an amazing verdict against Walmart for a slip and fall case in which Phil Meinkoth and Allison Pritchard from Olson Injury Lawyers achieved just a phenomenal result in Jefferson County. So, Phil, Allison, welcome to the show.
Thanks for having us on.
Yeah, it's great to be here.
So before we jump into the facts of this case, which there are so many interesting aspects, both evidentiarily and legal rulings about the case, Phil, let's start with you. How did you always know you wanted to be a trial attorney, or how did you become a trial attorney?
Yeah, so I knew I wanted to be a lawyer for a long time. When I was in high school, my mother, in her wisdom, said, "All right, you're not sitting around in the summers doing absolutely nothing." And she knew somebody who worked as a paralegal at Legal Aid Services of Stillwater, Oklahoma. And so I was kind of interning there from high school, and uh, right away it was kind of shocking to see how a lot of the systems that are in place are very bureaucratic, and it can be hard for folks to kind of get what they deserve. And so it was just amazing seeing these hardworking people kind of cut through that for folks. And ever since then I knew I wanted to be a lawyer. Went to university for undergrad that had a law school connected to it, and I haven't looked back.
So did you grow up in Oklahoma then?
I did, yeah.
Oh, that's fun. My wife is from Oklahoma, from Edmond. So I was just in
Hey.
Oklahoma. I spend a lot of time, more than I should, in Oklahoma. So did you go to college and law school in Oklahoma?
I did. So I was born and raised in Stillwater, where Oklahoma State University is, but
Yep.
my parents are both professors there. So I knew, all right, I absolutely don't want to go there for college. Ended up going to a small university, University of Tulsa.
Oh, wow. Okay. And Tulsa is just a lovely town. Would you agree with that? That Tulsa is awesome?
I would absolutely agree with that. That is the, let's call it a 5 mile radius from the center of downtown Tulsa is my favorite parts of Oklahoma right there.
Well, I'm definitely going to digress and hijack this podcast for a second, because I know that we were talking off air that Olson Injury Lawyers, personal injury lawyers, whatever Sean Olson's firm is licensed in both Wyoming and New Mexico. So my question is there any interest in getting licensed in Oklahoma?
Not for me. not
Okay.
not for me. I think I've come to love the Mountain West. It's hard to step away from that.
All right. So you do undergrad and law school is at Tulsa as well?
No, for law school, I moved out here and went to University of Denver.
Got it. So in law school, did you know I want to be doing trial work because of the experience you had doing legal aid?
Yeah, pretty quickly. I had a brief interest with copyright law for a little while in law school, but as I'm sure everyone may know, the University of Denver has a pretty active trial ad program, and I got involved with that my 1L year, and just I think right away I knew that that was what I wanted to do.
How did you, once you got out of law school, give, if there's young listeners that are also thinking they want to get into trial work, do you have any advice or suggestions on how to get your foot in the door?
Yeah, I mean, you would be amazed at how many mock trial programs there are. I mean, even I didn't participate too much, but even in my high school, I remember there was like a mock trial club. And so there are opportunities, and I think that's really the best way to get a feel for it, because there's really I think there's almost two entirely separate skill sets when it comes to the work we do. There's the in courtroom trial work, and that's a skill set in and of itself. And then all the procedural stuff to get you there is a whole separate set of skills, I think.
Isn't it interesting to think back on law school, and you had sort of the law review people and the moot court people? At least that was my experience. And I was a moot court person, but in the law review people, they could write so well and they could cite everything. And it's like if you could just marry that skill set And there are a few lawyers I know that were on law review and are these amazing trial lawyers, and I look upon them with envy. I don't know if that was your experience at BU, but that was mine.
No, definitely a very similar experience.
Allison, what about you? Did you always know that you wanted to be a trial lawyer?
Ooh, no, hard no on that one. I
Okay.
wanted to be an ambassador, to Paris. Shout out to Mary-Kate and Ashley Olson and their movie Passport to Paris. Very formative for me. I was very much so into politics. I went to
Mm,
undergrad at Regis University in Denver, and I majored in international relations. I lived in Paris during a study abroad program, realized I did not like Paris. So I came back to the States and then I did a semester. Regis had a program when I was there called the Washington Program. And
mm.
I went and lived in Washington, D.C. for a semester. Thought I loved it, moved there, had a job there, and realized I despised Washington, D.C. There is nothing good that is in Washington, D.C.
Definitely not right now.
Not right now. So, I sat there thinking, "What am I supposed to do with an international relations degree?"
Hmm.
And I went to law school, and in law school, focused on environmental law. I wanted to be an environmental, law attorney. I was not involved in the trial team. I did do STLA my first year, so
Okay.
Student Trial Lawyers Association, and
Mhm.
I was named best advocate during one of my uh, mock trials, but outside of that, I was convinced I was gonna be an environmental attorney. I was on law review. I did not love law school. It was very difficult for me because I didn't do, the trial law programs like my now husband did, and so then I got out of law school, applied to the EPA, had an interview, and Trump got elected. So,
Wow.
yeah, so I was
First is this the recent election or the first
no,
time?
this was the first. So this was 2016.
Okay.
I graduated in 2016, took the bar in July of 2016, passed, and then I was licensed October 31st, and when I had my interview with the EPA, they said, "Hey, look, we don't know that we're gonna be hiring." So,
Hmm.
I took the first job that I could find at a boutique firm in Denver, Shalat Hatton& Banker,
Oh,
and
yeah.
I worked there for just under 2 years, and it was a fantastic experience, and that is where I learned my calling.
Wow.
I fell into it, and it was a very good stroke of luck.
Wow. So where did you go to law school?
University of Denver.
Got it. So just a small digression, but my undergraduate degree is in environmental conservation, and I also thought about going into environmental law. I went to CU Law School, but then it just seemed like the most boring thing in the world. And so I thought, okay, that was sounded good on paper, but not good in practice. And trial work seemed much more adrenaline fulfilling, which sounds like you probably saw at Shalat's firm, which they do a lot of great work, including a lot of ski cases.
Yeah, they do, and it was, being under Evan Banker and
Hmm.
learning from him, it was a fantastic experience. He's just such a good soul.
Wow.
So, yeah, so that was really fun, and then I went off, started my own firm, had my own firm for 4 years, and, then Sean came to me and said, "Hey, do you wanna join?" And I was like, "Well, I'd be dumb not to," so
Well, knowing Sean, I would agree with you because he's he is wonderful. All right, well, let's jump into this case because for our listeners, this case is educational on so many levels. And Phil, I know that you sort of took the lead on this case. Give us a little bit of the background of the facts of the case, what happened, and do our listeners a favor and let them know what the result was, and then we'll dig into the specifics of the case.
Yeah, so as you were telling folks, this was a slip and fall at Walmart. Walmart had a morning stocking of ice bags to those front freezers, and the ice cart that was stocked in those bags sat for several minutes in the front of the store where the checkout counters are in a large pool of melted ice and water, just sat there, and 30 whole minutes went by with that on the floor, employees walking through, and no one did anything about it until our client fell in it and absolutely shattered her patella.
And how old was your client at the time she fell?
She was 68 at the time,
Okay.
which we had a couple jurors say they were shocked by that number because she's a very athletic person. But yeah, older woman.
Only I ask because it seems to come up in every slip and fall case. Were there any concerns about the shoes your client was wearing? Did that become an issue?
Yeah, absolutely. So she was wearing, those thong style flip flops,
Hmm.
and that was definitely an issue that came up at trial. We focus group our cases. We knew that was going to be something we would have to address. But at the end of the day, this fall happened in August. It is not unusual to have folks come into the store, and both Allison and I had a couple cross questions for the Walmart employees about where they keep their signs that say, "Hey, sandal wearers, enter at your own risk."
Right. And I guess I know that the result did include some amount of comparative negligence. Is that right?
Yeah, so at the end of the day, total verdict was about 240,000, and our client did catch 25% comparative fault.
Was that comparative fault based on the shoes or was it based on the not looking where you're going type comparative fault?
Well, I think it was more of I think there's a balance. I think it was a little bit of the not looking where you're going. I also have a theory that I couldn't get it ferreted out. I think we had one juror who was maybe a little skeptical, was actually a previous Walmart employee. And so I think that maybe was a negotiation that occurred.
Yeah, because and I know we're kind of bouncing around a little bit, but this idea that the shoes, what you wear when you're going shopping is a form of comparative negligence. And I will confess that I tried a case against Whole Foods. It resulted in a defense verdict where our client was wearing Crocs. And these were like the most worn Crocs you've ever seen in the world. And it was a real problem, but I struggled to wrap my brain around this idea that, it's not just in hindsight you shouldn't wear flip-flops. And I assume it wasn't raining on the day that you shouldn't wear flip-flops, but the fact that it would have to be you did something a reasonably careful person wouldn't do. This idea that negligence means that wearing flip-flops, you had to have been negligent. Candidly, and in your case, it just seems crazy as a matter of law that you could be negligent for wearing flip-flops in Colorado in October on a day when it's not raining.
Yeah.
Was it
And
argued by, and I know, tell the listeners who the defense attorneys were in this case, because I know they're very good.
yeah, so our defense attorneys were Sutton Booker, Ashley Larson, and younger associate there, Nate Moyer. And
Okay.
they're very good lawyers.
Mhm.
Absolutely.
Did they argue? Did Ashley how did she go about arguing, if at all? And I heard you say before that you think that this 25% comparative fault may have been a compromise. In other words, maybe other people thought there wasn't negligence against Walmart, so they dropped 25 comparative negligence on your client. Did Ashley actually argue in any concerning way for our listeners that your client was comparatively negligent, and if so, how?
Yeah, so I think larger than the shoe issue, the surveillance footage, our client came out of the restroom and actually walked through the area where she would later fall
Okay.
about 5 minutes before, a little less than that. And so I think that was actually the real comparative fault risk was, hey, you've got someone walking through. If you're saying this was something that was so obvious, a danger that Walmart should have known about, your client should have known about it as well. And so I think that was really sort of the thrust of the comparative fault argument more than the shoes were. The shoes
Mm.
did come up, but it seemed kind of an aside. And so, yeah, there was a lot of, hey, everybody's kind of got to be looking where they're going. That was sort of
What
the
what did your client say in her deposition about when she walked by the area 5 minutes before? Did she notice any water or nothing?
So she does not remember seeing it at all, does not remember looking down at it, anything like that. At the time, her husband was out in the store and she was looking for her husband. And I
Hmm.
think that, just thinking about it from I guess, a larger strategy perspective. When folks come into these stores, there's a reason that all the merchandise is at eye level, all the signs are at eye level or above. These stores know that their customers are shopping for merchandise. They want to draw their attention to that merchandise, and they don't have signage or merchandise on the ground. They know that folks aren't looking down when they're walking.
Yeah, fascinating. Now, you mentioned the surveillance footage. Talk to us a little bit about how important surveillance footage is in a case like this and how we might go about making sure we actually get all of the surveillance footage that might exist. Maybe you have some practice pointers for our listeners.
Yeah, just following through on depositions and written discovery. In this case, this was the first time I had encountered something like this. In their initial disclosures, Walmart told us that they had surveillance video, but were not producing a copy of it until after our client's deposition. And we immediately brought that up in the case management conference, and Judge Pullen, told them that they had to disclose it within 10 days. So there was, a fight from minute one about that. You know, a lot of the employees who created witness reports, incident reports, referenced that they had looked at the surveillance video. And so, following up on depositions and making sure you get these people to commit on record, well, I saw this amount of footage, is critical, because they may only disclose to you a select period of time, and their argument is, well, the rest of this isn't relevant, but it absolutely is, because all the details in the hour before our clients fall, and even the details in the minutes after our clients fall, were really illuminating.
Yeah, I want to dig into this deeper because I do find it critically important and fascinating. First of all, on the written discovery piece, did you issue like an RFP for all surveillance footage for the entire store for like the day before to some period after? What should our listeners be asking for in written discovery to at least start the process of making sure the other side at least is on notice they should be giving whatever they have that's arguably relevant?
Yeah, so I had limited my RFP to just the day of the incident. Our clients were from out of town. I do think there's an argument to be made if you have, prior instances, prior incidents, to try and get surveillance video from, the days before, the days after. I do think that that sort of stuff can be useful. In this case, we had limited it to just the day of.
Okay.
And we, initially got 5 minutes of surveillance video, which captured the client's fall. And then we had to kind of claw for more, because it turns out there was a full 2 hours, hour before, hour after, that wasn't initially given to us.
When you say you had to claw for it, did you have to file a discovery dispute hearing? Were they acknowledging that there was more that they weren't giving because they claimed it wasn't relevant?
Yeah, it came up on a conferral for a 30B6 topic, I believe. And yeah, just in talking, learned that there was more out there. And we didn't have to go all the way to a formal discovery dispute hearing, but I was pretty clear that, hey, I need this by the end of the day, or that's where we're going.
Hmm.
And then they did end up producing the rest of it.
Yeah, and I'm glad you mentioned the 30B6 topic because as you were talking about this, I was thinking, well, next time this comes up, it seems like a really good idea to have an area of inquiry, cameras, storage. Was that in your 30B6 notice, and did they push back against that?
It was. They pushed back on several topics. The sort of standard stuff you see,
Yeah.
over broad, not specific enough, things like that. I'm certainly a younger attorney, newer to this practice, and so I may not be imparting any wisdom that your listeners don't already know. But I'm a big believer that the 30B6 deposition is such a powerful tool. And crafting your notice, I mean, I drafted my outline of the deposition before I drafted the notice,
I love
so
that.
that I could get very specific in the topics, because I knew exactly what we needed to hit on. And so having very specific topics about where the cameras are, because it's It's Walmart. You can walk into any Walmart and they don't just have one surveillance video there. They've got angles all over the place. They have cameras above each and every cash register. So being able to have a topic about that so that they have an obligation to produce someone who can testify to where that surveillance video is or if it wasn't saved, why it wasn't saved is a very powerful tool.
And I totally agree. The other piece of this that we have been using, I'm curious if you did anything in this case, is when you know there's going to be a 30B6 deposition, including proactive language about the amount of time they have to object and confer in the case management order. Did you have any of that? Because what I have found is it just becomes this morass of delay. You get this 4-page single spaced letter of objections on your 30B6 topics. And then because they expect you to respond in writing, and then they can't get them on the phone to confer, and you can't set the dates. Did you all include any language in your case management order about the 30B6 proactively?
I wish we had had this conversation before because I did not, and let me tell you that that is a lesson learned because we started hearing. I mean, and my exact dates might be wrong, but I sent the notice in October, and we were hearing, well, we're so close to Black Friday. How could we possibly produce anybody who's got the relevant knowledge because they've got sales they're worried about, they've got this they're worried about,
Oh
and
my
it dragged
gosh.
on. It dragged on
Yeah.
for yeah. So I think going forward, having that language in the case management order is absolutely a practice I'm going to adopt.
All
That's
right.
something I've never heard of, and 100% will be including that in my CMOs because I'll send 30B6s and I just don't hear anything.
Yes. Yeah. Yeah, I agree. There's just for our listeners, there was a great discussion on this on the CTLA listserv recently that has great language. And I think it is absolutely a must anytime there's going to be a 30B6, because you might as well fight about it at the case management order stage. And if they're actually going to push back, you could very credibly explain to the judge the concerns that come up in cases like this, because it really is like pulling teeth to get these depositions set. So you engage in this, you do the 30B6 deposition, and I want to go back a little bit to the facts of the case. So the pallet of ice is delivered, and did you say it was there for 7 minutes left unattended where it was dripping water?
Yeah, so the pallet of ice is delivered. The Walmart contracts with another company to have this delivery, and so as the leftover ice bags, the freezers are full, are getting taken across the front of the store to the exit. The folks from the ice delivery company get pulled off to go speak with one of the Walmart employees. And so we see in the surveillance video that that ice cart with these bags of ice just kind of, sitting in front of the checkout counters. And I think it was about 3 or 4 minutes that it sat there before they come back and pull it away. And if you just, uh, when I first got that surveillance video, I just put a little piece of sticky note on my screen where that ice cart was. And sure enough, that's exactly where my client ended up falling 30 minutes later.
Okay, so ice is there for unattended for a period 5 to 7 minutes. They take it away 30 minutes later, your client falls in that exact area. Is that right?
That's right.
Was there and then fell and broke, and I apologize, I should know this, armor it was the arm?
Kneecap.
Kneecap. Oh gosh. So I'm assuming there's an incident report as a result of that kind of fracture, is that right?
There are, yeah.
And did the incident report did they admit that there was water on the ground? Because usually on those incident reports, they're supposed to look, see what's on the ground, take photographs. What beneficial information, if any, was included in the incident report?
The first couple incident reports did say that there was water on the ground, and then there was another. They called this one a witness statement from another employee that wasn't filled out until 2 months later. And
Hmm.
on that one, the person actually put that the water was there from the morning ice stocking.
Okay.
So, yeah, that was a huge tool that we got.
Did the surveillance show any employees of Walmart walking by the area in that 30 minutes?
Absolutely, we had. probably, I don't remember the numbers anymore now, but 8 or 9 times a Walmart employee walked in and around exactly where that spill was. We counted 4 separate Walmart employees who walked almost immediately over it, and, sure enough, didn't do anything about it.
Were you able to establish in either written discovery or the 30B6 of Walmart that their philosophy is that all employees of Walmart have an obligation to always be looking for hazards on the floor? So it's one of these, like, everybody is in charge of making sure the floors are safe.
Exactly right. We did
Yeah.
get that from the 30B6 representative. If you see something, that's your responsibility. That's your spill. They, of course, don't want to put it in as direct a language as that. So you kind of have to go back and forth on exactly what that means. But yeah, and all the Walmart employees, we got this from the 30B6 representative as well as another employee that we deposed, confirm we're trained on this. That's something that is brought up in every training for every Walmart employee. It doesn't matter if you're a maintenance employee, someone who's behind the checkout counter, someone who's stocking. You're all trained on it.
So what was Walmart's excuse for all these people walking by and nobody doing anything about it? They didn't
It,
see
it
it?
yeah, exactly. It boils down to in the Premises Liability Act that I mean, there's a lot of instances of that word reasonable. So the first is, knew or should have known using reasonable care about a danger that provided them an opportunity. Hey, look, it's hard to see on the surveillance video. Your client didn't see it. Why should we have seen it as well? And then, reasonable steps to protect against that. That gives them another area. How long was it on the floor? What else could we have done?
Yeah.
Sort of.
Now, Allison, I think did you do the rebuttal close?
No, I handled all the cross examinations
Mm.
of their witnesses, and then I did 2 directs.
All right. So when you're crossing their witnesses, were you able to in my mind, there's this sort of theme: when everybody's in charge, no one's in charge. So did Walmart have somebody's job it was to actually do the sweep checks or whatever Walmart wants to call them, to actively look for dangerous conditions, or is it just incumbent upon everyone to sort of, when they see something, say something?
Here's the interesting thing, Keith. Walmart has policies and procedures that says safety sweeps are required. They should be doing them once every hour in high traffic areas, once every 2 hours in low traffic areas. And they emphasize it, but there's no enforcement.
Hmm.
There's no sweep logs, safety sweep
Wow.
logs, and I've had PLA cases where in other companies there are sweep logs, so you can track when the employees are doing something. That's Walmart doesn't have that, which was very interesting to me. So, it's really on an honor system, and when crossing 2 of their employees one was upper management at the time, he no longer works at Walmart, and one continues to work at Walmart at a different store and is upper management. When asked how they would enforce this, they said, "Oh, well, we have video cameras if we need to." But that's retroactive enforcement. So if you think someone's not doing their job, then you can go check the videos, but you're not doing that in real time. So it was interesting because it's everyone's job, towel and pocket program. If you see a spill, you clean it, you own your work, and there's no enforcement to making sure that people are doing their work.
Was that was so well articulated. Were you able to sort of convey that message and theme when you were crossing the Walmart employees and Walmart personnel?
Yeah, and I think a really it was split into 2 of their witnesses. 2 of their witnesses were really important. So, the first witness was a male who no longer works at Walmart, but he was a very likable guy, really, really likable, and he was a team lead for the front of the store at the time that the incident occurred,
Hmm.
and I walked through his responsibilities with him as a team lead. You're responsible for ensuring that your employees own their work. You're responsible for encouraging them to do their job. You're responsible for making sure that they do these safety sweeps.
Hmm.
And he actually offered me a bit of information in his cross-examination where he knew that these pallets full of ice, when the ice was being stocked, would drip. He knew it. And so at the end of I think I closed out his cross saying, "Well, you knew that this happened, but you didn't walk the path of the pallet to make sure there was no water on the ground." And he said, "Yeah, I didn't do that." So it was, so that was a really critical one, was really just showing he did not do his job. He
Hmm.
was aware that there was a mess, and Phil can get into this with the, surveillance footage, but there where the pallet was originally in front of the ice machine, there was a gigantic mess there that we saw them cleaning up on the video footage, and
Wait,
we
after the fall?
no, before.
Oh,
Like, when the pallet leaves, so the reason why the pallet was sitting unattended was because Walmart, the employee, told the ICE employees to come and clean up their mess in front of the ice machine. That's why the pallet was sitting in the middle of the walkway unattended, was because we were cleaning up a mess of water, and you can see this on the video footage. And so it was, I walked him through the video footage. I told him, "You knew there was a mess from the pallet." "Oh, yeah, and I know that this happens, with these pallets." So,
yeah.
it happens. You know there's a mess right here on the morning of, and you don't follow that pallet out. That's you not doing your job. And so it was the same with the next witness. She was a female, very well spoken. The jury received her very well. And, I realized mid-cross that I had to change my direction and really make her a victim of the corporation. The
How'd you do
corporation
that?
it's more of, you it was asking her, "Well, so you're trained that these safety sweeps are important, right? Right. And you're not told that you have to enforce these safety sweeps. Your employees are not required to show that they're doing them, right? Right. Well, that sets you up for failure, doesn't it? Because you can't confirm what your employees are doing. And then she was like, "Well, I have other ways to do it." And it's like, but those aren't you're not doing those in the moment. Those are retroactive ways that you can check their work. So it was an interesting experience.
So, in hindsight, because it sounds like you were in the heat of battle, you pivot and change your approach. Kudos to you for that. And as I'm hearing this, I'm wondering if you go back the next time you have a case where there is no enforcement of sweep logs, if you would if you would have approached it any different than you did here. Because I agree, it's such an interesting idea, because I'm with you. I don't recall ever having a case where there's this idea that people are supposed to sweep, but there's no enforcement, no discipline, no accountability whatsoever. And my mind right now is just spinning with different analogies with our kids, with like, so I don't know. I don't know if, as you have sat with this verdict in this case, if you've come up with any brainstorms that our listeners can apply to cases going forward.
I'll have Phil touch on this because, to be honest, I don't remember a lot of my cross-examination.
That's
Heat of the moment, and then I kinda leave it. I
yeah.
was very proud of them, I just don't remember a whole lot of them. I would say I'd probably keep my cross-examination the exact same with the male employee. I felt like that went really well. Maybe with the female employee, because she was a higher up. At the time of the fall, she was the most senior, management in that store. So I may have focused things a bit differently with her. She was very well coached how to
Uh-huh.
answer questions more than yes or no. I got a little spicy with her in my cross examination, which I realized I needed to back off of, and I did. So maybe I would have changed my approach a bit differently with her in terms of enforcement and making sure that your employees are doing their job. Maybe I would have hit on it, in a tactfully different way, but, Phil, do you think we should have changed that?
No, no, well, what I was gonna say is, yeah, to Allison's point, that I think that pivot was necessary and she executed it very well. we had a juror who was sort of nodding along to some of the points that this management employee was bringing up during their direct. And so, shifting it to, well, the way Allison spelled it out was very clear where, look, you're responsible for these employees under you. And if they're not doing their job, that comes down on you, their manager, and you don't have the tools to check that they're doing their job. So that puts you at a disadvantage. It was very well structured to kind of make, hey, look, this middle manager is sort of at the mercy of this corporation, just as our client was. It was very well structured. I think in a context where you don't have enforcement, it's sort of a balancing act because here there was no tools for the enforcement to take place. There
Hmm.
were no sweep logs. If you had a situation where there were sweep logs and it was well documented that they just weren't being done, then I think there's a saying that bad conduct without consequences is conduct rewarded,
Hmm.
something like that. It encourages that cutting of corners in the future.
Yeah, our listeners are getting all kinds of one-liners to all kinds of themes they're going to apply to their next cases. Couple of little nuanced questions I want to ask. I know from reading your overview of this case that there was a non-party issue with the ice delivery company. And I believe, if I'm not mistaken, you were able to have that struck. Can you advise our listeners on what that issue was and how you were able to strike the non-party designation?
Yeah, so I'll do a quick overview and then more the nitty gritty because it is actually more complex than on face value. But
Okay.
as I was talking about earlier, Walmart contracts with a company to have these, ice bags delivered to its freezer. And so they had named that company as a non-party at fault, essentially saying the whole reason the pool of water is there on the ground in the first place is because of this, company. So we moved to strike it, or in the alternative, a finding of law. So this is the more nitty gritty aspect. When they initially designated this company, they designated them as unknown ice vendor, and it wasn't until months later that they supplemented with the name of this ice vendor, and things like that. And so that was one of our grounds for the motion to strike. But what the case law, and I'm happy to chat with folks about this in the read one and read two cases, kind of says is when you have a landowner, they are not allowed to delegate their responsibility to keep their premises safe. And so there are cases that indicate that in this context, you can have a non party at fault, but after the verdict, any fault apportioned to that non party is still the responsibility of the landowner. And so, we had asked for that in the alternative because, from my mind, it was like, look, end of the day, this is the, non-delegation doctrine at
Yeah.
work.
Yep.
Doesn't
Yep.
matter that, think about it like a customer. If a customer spilled a drink on the floor, Walmart doesn't just get to leave it and hope that it gets cleaned up by somebody. That's still their floor. And if they know it's there, they got to take care of it.
So what did the judge struck it altogether as opposed to, so I'm hearing you say you filed a motion to strike it, or in the alternative as like a 56H matter of law, that if they are on the verdict form, Walmart owes for any portion of liability against the ice vendor. Is that right?
Exactly.
Okay. So talk to us a little bit about Judge Poland. I'm not familiar with Judge Poland. Also, talk to us a little bit about Jefferson County. What did you think about Jefferson County, which is, if I'm not mistaken, where your office is, because you guys are in Golden, right?
Exactly. Yeah.
All of our listeners are jealous about your office in Golden. I just love Golden. So tell us, what do you think? How do you feel about Jeffco jurors, and what did you think about Judge Poland?
I I have nothing but positive things to say. I know Jefferson County can be, depending on your jury pool, a little tough. We certainly had a lot of former Walmart employees in our jury pool, but all of the jurors were very thoughtful. In voir dire, they had a lot to say. They clearly, in our chat with them afterwards, thought about the case a lot and were really, they did their jobs well. Judge Poland, I've also got, only good things to say. I think
Hmm.
he's a little newer to the bench, if I remember right, when I first sort of, filed the case, but his rulings were all very well reasoned and thought out, and he put on the record, even when he was making verbal rulings, a very sort of detailed step-by-step analysis. And so, yeah, I thought he did a great job.
I guess you're about to find out how appellable the verdict is, because it seems like maybe you're about to get a notice of appeal if they haven't reached out to. I don't know. We'll see. I guess we'll see.
Yeah, and their deadline's coming up, and I haven't heard anything, but they very well may.
So I want to talk a little bit about your damages and the ask y'all made with the jury. So first of all, broken kneecap sounds awful. Was there ongoing or evidence of impairment from the way in which that fracture healed?
Yes, but this is that classic sort of catch 22. I mean, our client was just very dedicated to her recovery and
Mm.
made great strides that were, pretty undeniable in getting better. So she still had, yeah, ongoing pain, you know, things that you and I would not think about, going upstairs, bringing in groceries, things like that, still really bugged and irritated her. Standing for long periods of time, being able to, crouch down on your knees for any reason. I think one of the things that was the most powerful testimony from her, she used to be a nurse, and she says, I can't get into, proper CPR form anymore. And, hopefully I
Wow.
never have to do that. But that was something that was always important to me, knowing is that I had that skill set. And now that's not something I can do. So physical impairment did play a role. Her treating provider, her surgeon, was very helpful for us. He was very, involved from day one. His medical records and his communication with us was this was a severe fracture. It was one of the worst he had seen, and so he was very, you know, dedicated to the case, and was very vocal about how amazing it was that she made the strides and improvement that she did given the injury.
And I
Who
think
was yeah, yeah, before who was the surgeon? Just because I think it's always useful for listeners to know if there are surgeons out there that are willing to work with you in a case like this. Do you remember the name?
Yeah, his name is Dr. Rishi Garg. His practice is actually out in California, near
Hmm.
Monrovia, where our client lives.
Oh,
So we, flew him in because he was
oh,
our damages expert. He was willing to work with us from, sort of day one, even before we filed the case.
oh, that's so great. Allison, did you have comments about sort of the impairment or the surgeon?
yeah, I think what was important also in the impairment is that she is for the rest of her life missing the lower half of her kneecap. It's a visible
Whoa.
impairment, when she shattered the lower half of her patella and obviously had surgery on it. The surgery couldn't be performed until the swelling was down, right? So she had a surgery about a week after the incident occurred. And when the surgeon went in, he had to pull out the shards of bone from her lower part of her kneecap. And so, he was able to surgically repair where she was able to get the flexion back, but she cannot straighten her leg fully. She has the
Wow.
maximum amount of flexibility that you can have without the lower part of your kneecap, but she will not have a lower part of her kneecap now in her left leg.
Wow. The did you have an actual like impairment percentage or a functional capacity evaluation to talk about the extent of the impairment, or did you just sort of roll with your client and the surgeon?
Rolled with the client and the surgeon, and yeah, unfortunately, well, fortunately for our client, she actually got her full range of motion back.
Oh,
Hmm.
And so, the facts are what the facts are in a case like that. But, the surgeon testifying, the surgeon had, uh, you know, right after the surgery, a photo taken of the bone fragments because he
Wow.
was just, he was very clear that this was a severe fracture. And so his testimony in combination with, our clients as well as our client's husband, very clearly sort of indicated what, the impacts of this were.
What I'm loving about your story, it's really your client, because I love the Jesse Wilson from victim to victor, and having a client that comes in that is like, I'm going to persevere through this. I'm going to do whatever I can. It almost seems like this verdict is speaking to his message, which is like, that's the kind of people you need to get good verdicts. Do you have any thoughts about that? I guess what I'm trying to ask is, do you have any idea how the jury perceived your client?
I think they really liked her. Our client was a very likable woman, is a very likable woman. Her husband, they're nice people. They remind you of someone you'd see in a Disney movie, or you're just your classic sort of wonderful grandparents. And I think, the perception that came about in trial reflected the facts, which is just that this was, you know, a company that was kind of brushing this poor person off and just not giving them the respect that they were entitled to.
Yeah. Let's talk a little bit about pretrial settlement negotiations and what your ask was to the jury. But before we do that, what was the total amount of your client's past and future medical expenses, if you know?
Yeah, so the medical expenses in total were about 67,000
Okay.
and change, somewhere in there. No, as we talked about, she, she put in the hard work. She put in a lot of time making sure that she was bouncing back as quickly as she could. She took that
Hmm.
very seriously, and so she got to a point where she didn't need future medical treatment. She was at a point where it was just, this is as good as it's going to get.
Okay. Was there any wage loss, or I can't remember if you said she was retired?
Yeah, she was retired, so we didn't have a wage loss claim. So we were primarily focused on, the economics and physical impairment on economic.
All right. So I think our listeners have a pretty good understanding. You've got 67,000 in meds, have a really good understanding of the liability aspects of this case. Were there any meaningful pre-trial settlement offers from Walmart? And if so, when?
Not until the very, tail end. Sometime in the first month or two, Walmart made a statutory offer of $10,000. And that was sort of all we heard. We went to mediation. They got up to 50, 55, somewhere in there. And then immediately after that, filed another statutory offer at 75. And that was all we heard until about the, couple business days before trial. So the Friday before, they started, putting quote unquote actual offers on the table. Went up to 150 before they stopped, and we had been very clear that our number was 175. And
Isn't it
so,
funny? Can we just stop and comment about how that happens every time? If you tell a defense lawyer or a defendant that your bottom number is 175, it is without fail that they will say, we are only going to pay 150 every
yeah,
single time. so,
and that's exactly what happened here. And that's exactly what happened
so you guys went to trial over 25 grand on a slip and fall case at Walmart, is what
here.
I'm hearing.
I would argue that Walmart went to trial over 25 grand. I think we were pretty clear from day one, what our client had been through, and it was Walmart's choice not to take that last step. And so,
and,
yeah, we went to trial over it.
and just to remind everyone, so because I have the printout here, the verdict was 53,000 non-economics, 67 economics, 128 disfigurement impairment. So I don't know what that math is. 250, we'll call it ish, plus interest, which is of course accruing. Tell us a little bit about your thoughts about the damage asked to the jury. Did you do like a per diem? How'd you go about asking for money and how much did you ask for?
Yeah, we did do a per diem. In closing, we, said, look, minimum wage in this country, it's less than it is in California, less than it is in Colorado. It's 725. She's going to live the rest of her life without that bottom half of her kneecap. She's in pain when she does this. And, this was a plan we had discussed with our client, you know, going back, that they were, on board with. And so we did the math of that. Let's say this is going on for another 10 years. Here's what the number is. And, folks, she's not asking to become the next, millionaire. In fact, she's going to ask you for half of that number. And
Oh,
so
wow.
what the jury awarded was penny for penny what we asked for.
Wow. So, all right, I want to talk that through because that seems brilliant. I
And
love that idea of we're not asking for that, we're asking for half that. Tell us about the thought process there.
well, the thought process was, as it's just about being straightforward with folks and being honest. And our client was not trying to hide the ball. She still has pain, but it's not every second of every day. It's really context dependent. And so, we were pretty straightforward with the jurors that, hey, look, she was being honest with you. She's not here, trying to create some sob story. She's
Hmm.
being straightforward with you, and so are we. And so that was sort of the thought process there. We had a couple folks on the jury who had their family businesses sued before, and
Oh.
so we knew going in we were going to have to, be direct and be honest and be the more credible lawyers, and I think we achieved that.
And I think
Did the Yeah, go ahead, Allison.
oh, sorry. I think something that's really, really important and crucial here is we all know as trial lawyers that our clients' trust in us is the reason why we succeed, right? We pivoted the day of closing. And Phil and I had talked about this strategy a little bit, but it became concrete on the day that we made that ask. Phil made a pivot and we looked at each other and were like, we're not gonna ask for 400 or $500,000 because that was where our initial calculation brought us with that per diem. We cut that in half, and our client trusted really Phil so implicitly to say, this is yours. If you think that that is the right call, I'm gonna go with it. And so we made a judgment call based on reading the jury, and I'm so proud of Phil for having the courage to do that and to knock down our number because the credibility soared.
Yeah, to that point, our client had been, saying, we're 175 was our our number, and so, anything above that, I think they were excited.
And so I'm hearing that the decision to say, we're just gonna ask for half of it, was that literally like a game time decision? You guys are reading the room and you're like, rather than asking for what we planned on, we're gonna ask for half.
Yeah, yeah. I think
Wow.
we had a sense that there was, one juror who was kind of on the fence. And again, it's all about just being credible, being yourself.
Gosh, like I told the listeners at the beginning of this podcast, there are so many lessons to be learned from this trial. Did the defense throw out a number in closing, or were they going all defense verdict all day long?
Yes and no. They went all defense verdict, but then at the very end, kind of had a couple minutes of, well, if you get here, we think, and I don't even remember what the numbers were. They were so phenomenally low, but also asked for a 50-50 split, which, of course, would actually mean zero. So all defense all day long.
When the defense asked for the 50-50 split, did that mean that when you got up to do rebuttal, you had to like really hammer, this is what they're really asking for, just to make, because I'm always so terrified of the 50-50 split. It freaks me out.
Yeah, I think in hindsight, spending some time on that jury instruction probably is advantageous. About, look, you've got a jury instruction that says if you award 50-50,
Yeah.
it's not a compromise. It is a win for Walmart. But they had thrown out some stuff that was just so callous in their closing that my rebuttal was pretty much they had made metaphors to, hey, this is Monday morning quarterbacking, sitting back. And so the first words out of my mouth was, folks, this is not a game. We're not talking about a football game. We're talking about a human being. And they want to treat it like it's just, if only our quarterback had thrown that pass instead of that run. That's how they want to boil this down. And don't let them do that.
Wow. Were you able to talk with the jurors after?
We were, yeah. They were very nice and let us pick their brains a little bit, which is always just such great insight. It is so wonderful to hear from jurors after trials, and I know I'm always trying to sharpen my skills. There's always lessons to be learned,
And that's
and so
really where in talking to the jurors, that's where we understood that there was compromise happening in the room because one of the jurors actually told us, "Well, I would have given you guys more." I was gonna give you guys more money, and I think it boiled down to 2 jurors, 1 juror being on the fence about everything. There was 1 juror who was really on the fence about everything, and that's where the compromise came in for the amount asked for plus the comparative. There was 1 juror who was definitely sold on liability, not so much on damages because, she I think that there's difficulty in assigning a number to pain and suffering. And then so those 2 were the jurors where we could tell, uh, yeah, that there was a discrepancy.
Yeah, that's I guess just big picture. What were your big and we'll start with you, Phil, then we'll ask you, Allison. What were your big takeaways from this case? In other words, what are the big I'll do this a little bit different next time, or this worked really well, I'll do it every time. Do you have some takeaways from this trial?
Absolutely. And the things I would do different are too many to count. Looking back, there's always things where it's like, I wish I dialed that up a little bit more. Being more aggressive with the 30B6, getting that done as soon as possible early, is huge. I've probably let them get away with a little too much delay.
Hmm.
And the 30B6 representative was our second witness, and our first witness was a Walmart employee that I had deposed. And we got him to say that, yep, he could have just taken 2 extra seconds and walked up and cleaned up that spill. And so having the defense tell our story for us, I think, was a huge driving factor. I think spending a little bit more time with that reasonableness instruction. We as lawyers live in this world of reasonable and what that means. But, just folks living their lives, that's not a word you have to consider the ins and outs of every day. And so really digging into what that means, I think can be very important.
Oh, that's fantastic. Allison, any takeaways that you have from this amazing result?
I think the biggest takeaway for me is just how fantastic of a trial team Phil and I are. And I know we talked a little bit about this off the air in terms of like men and women having one of each gender at the table. And I'll mimic what Phil says. It's really about the personalities. I am
Hmm.
someone who's like, "Put me in, coach, I get a little riled up sometimes, and Phil is much more I'm gonna be the calm presence and the deep breath, and I think we balanced each other out very well, so that takeaway is just when you feel confident in your trial partner, and I've tried a case to verdict with Alana Anzalone, I felt the exact same way. It is when you have when you have confidence in your partner, it makes it so much easier to try a case.
Confidence and it makes it a lot more fun, right? When you don't have to worry what someone's gonna do, they're gonna do a good job, you trust what they're saying, and, I it's sometimes harder than you think it would be to have that team that is, like, the go-to team, so, I'm hearing you say that you are thrilled to go back into the arena with Phil. He's right down the hall from you. You guys are gonna have lots more cases, lots more trials in the
Yeah.
future. Is that did I get that right?
Basically, I mean, I'm up in Summit County, so I have a remote office. I wish he was right down the hall from me, but in the days where I'm in office, he is. But we will be back in the arena together for sure.
Yeah, and if I may, just on that point,
Yeah,
I mean,
please.
if you ever have the opportunity to watch Allison in trial, I highly recommend it. She's very good. She had a cross of that we were talking about earlier, where I watched her, uh, metaphorically hand the witness a tank of gasoline and a match, and he lit himself on fire. I mean,
Wow.
she's got some skills, and in the build up to this case, we pick the brain of several CTLA member folks. I mean, the CTLA lister was a huge resource for me as a younger attorney. So, I mean, that organization is just very beneficial. The amount of insight that is out there is incalculable.
Yeah. Yeah, that's just fantastic. If people wanted to get a hold of you to co-counsel cases, because you're in New Mexico, you're in Wyoming, obviously a lot of Colorado. Phil, how do folks get a hold of you?
Yeah, anybody can shoot me an email or give me a ring. Our emails are pretty easy to remember. Mine's just Phil, Phil at Olson, Olson lawfirm.com. Allison's is the same way.
With 2 L's, not 1.
Two L's, not one.
Yeah.
Well, I cannot thank you both enough for coming on the show and imparting your wisdom. I have learned so much and am so eager to jump in the arena again. And it seems like these cases involving Walmart or King Supers or the various retail out there, we're always in our inventory. We're always addressing them, and it's so great to hear. There's been a run of successful cases, successful verdicts for these types of cases. So, congratulations to you both, and thank you so much for appearing on the show.
Thanks
Thank
to
you.
Thank you for joining us. We hope you've gained valuable insights and inspiration from today's courtroom warriors. And thank you for being in the arena. Make sure to subscribe and join us next time as we continue to dissect real cases and learn from Colorado's top trial lawyers. Our mission is to empower our legal community, helping us to become better trial lawyers to effectively represent our clients. Keep your connection to Colorado's best trial lawyers alive at www.thectlc.com.